Hello viewers, welcome back to my channel Legal Decipher. In the previous video, we had discussed about Chapter 14 of the Code of Criminal Procedure 1973. If you have not seen that video, you can go and check it. The link is in the description below. Today we are going to discuss about Chapter 15 of the Code of Criminal Procedure. We will go through the chapter and try to understand how the criminal procedure is followed and how the criminal courts work. So if you are new here, please like and subscribe to my channel to get the video notifications. So let's get started. So today we are going to discuss about chapter 15, which is a very small chapter but equally important. It talks about complaints to magistrates. So under section 200, the examination of complainant is done. A magistrate who is taking cognizance of an offence on complaint of a person shall examine upon oath the complainant and all the witnesses that are present. So the magistrate will examine the witnesses and the complainant upon oath. Okay. Now substances of such examination shall be reduced to writing. So all these statements that are extracted in such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. Now, provided that when a complaint is made in writing, the magistrate need not examine the complainant or the witnesses in these two situations. Either if that complaint is made by a public servant who was acting or purporting to act in the discharge of his official duties, or that a court has made that complaint, or if the magistrate makes over the case for inquiry or trial to another magistrate under section 192. Now provided further that if the magistrate makes over the case to another magistrate under section 192 after examining the complainant and the witnesses, then the latter magistrate need not re-examine them. So once the persons are examined before a magistrate of competent jurisdiction, then subsequently another magistrate does not need to re-examine them. Now section 201 talks about procedure by magistrate not competent to take cognizance of the case. So what happens when a magistrate who is not competent to take the cognizance of any case gets such kind of case? Then either of these two things happen. It says if the complaint is in writing, then it is returned for presentation to the proper court with an endorsement to that effect. So the magistrate will briefly give an endorsement that this complaint cannot be filed before this magistrate due to want of jurisdiction, and that complaint will be returned for presenting it to the proper court. Or if the complaint is not in writing, then direct the complainant to the proper court. Now section 202 says postponement of issue of process. So when a complaint is filed, an issue of process is thereby done. But if the magistrate on receipt of a complaint of an offence which is authorized to take cognizance or which has been made over to him under section 192 by another magistrate, then if he thinks fit or when the accused is residing at a place beyond the area of his jurisdiction, then either of these two cases the magistrate will postpone the issue of process against that accused and either inquire into the case himself or direct an investigation. So he will postpone the issue of process and start inquiring into the case himself or direct an investigation to be made by a police officer or such other person as he thinks fit, for the purpose of deciding whether or not there is sufficient ground for proceedings. Now provided that no such direction for investigation shall be made, so where this kind of direction regarding an investigation shall not be made in any of these two cases, where it appears to the magistrate that the offence complaint is triable exclusively by a court of session. So if the offence is of such kind that it is not in the power of the magistrate to try such cases, rather it is exclusively triable by a court of sessions, then in that case, or where the complaint has not been made by a court unless the complainant and the witnesses present have been examined on oath under section 200. So the other case is that where it was not made by a court, it was made by a party, and that complainant and witnesses, those are present, they have been examined on oath under section 200. Then in either of these two cases, such direction for investigation will not be made. Now, subsection 2 says that in an inquiry under subsection 1, if the magistrate thinks fit, then he may take evidence of witnesses on oath, provided that if it appears to him that an offence complaint is exclusively triable by a court of sessions, then he shall call upon the complainant to produce all his witness and examine them on oath. Subsection 3 says if an investigation under subsection 1 is made by a person not being a police officer, then he shall have for that investigation all the powers conferred by this code on an officer in charge of a police station except the power to arrest without warrant. So, if an investigation under subsection 1 is made, say for example, we think for a moment that such investigation has been granted to a police officer, that you go and investigate that matter, then he shall have all the powers conferred by this code, such powers that an officer in charge of a police station has, all those powers will be conferred upon him for the purposes of that particular investigation. But only power that he shall not have will be the power to arrest without warrant. So he cannot arrest without warrant. Except that he can do anything else that is provided by this code to an officer in charge of a police station. Now, the last section is section 203, which talks about dismissal of complaint. So it says that if after considering the statements on oath, if any of the complainant and the witnesses and the result of the inquiry or investigation, if any, under section 202, the magistrate is of the opinion that there is no sufficient ground for proceedings, then he shall dismiss the complaint, and in every such case he shall briefly record his reasons for doing so. So it says that if after considering the statements on oath of the complainant and the witnesses, and after the inquiry or investigation is done, whatever may be the case, after doing so, if the magistrate is of the opinion that there is no sufficient ground for proceeding and regarding that complaint, then he shall dismiss such complaint, and in every such case of dismissal, he shall briefly record his reasons for doing so as to why he dismissed such complaint. So that's all in this video. If you like my videos, then don't forget to smash the like button and subscribe to my channel. Thank you so much for watching this video.